trust to be exercised in a manner that 3. Brings honor to the nation and dignity of the office. To the extent that those grounds were established under Article 150, it simply means that the person of His Excellency the Deputy President therefore lost the capacity. And why that is important is that as you consider this question as to whether to grant the conservatory orders or not, would he be one person who could possibly be considered for that situation? And our answer is a simple no. Permit me to speak to the issue of now Article 149. Article 149 reads, within 14 days after vacancy of, in the office of the Deputy President arises, the President shall nominate a person to fill the vacancy and the National Assembly shall vote on the nomination within 60 days after receiving it. First point I would want to make, just to complement what my learned friend Mr. Mudomi has spoken to, as to the justiciability. If the Constitution says that within 14 days of coming into play of Article 145(7), is it practical, is it tenable that within those 14 days, if a party were to have come to court, then going through the hierarchy of the High Court, the Court of Appeal, and the Supreme Court, any dispute touching on that question of nomination would have been resolved? That then speaks to the architecture of our Constitution, to the extent that it is not contemplated that the person who has been impeached would therefore be able to run or even express interest for nomination for purposes of Article 149. Let me then take it one step further to relate Article 149 and 148. In particular, let me start this conversation from one step behind. Our Constitution at Article 1, Subarticle 2 speaks to how our sovereign power is to be exercised. In particular, it says the people may exercise their sovereign power either directly or through their democratically elected representatives. Now, we then relate this to the events of first Article 94, Subarticle 2, which says the role of Parliament shall be Parliament manifests the diversity of the nation, represents the will of the people, and exercises their sovereignty. What point am I trying to make? A lot of heavy weather has been made about the candidate who has been presented for purposes of approval under this Constitution. Now, one of the issues that have been raised is that there was no public participation in relation to the candidature of Professor Kindiki. My lords and my lady, allow me to just take us very quickly to the provisions of Article 149 to provide some bit of context. That within 14 days, allow me to just read it again, within 14 days after a vacancy in the office of the Deputy President arises, the President shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days. Vote is the word used. I want to persuade you, my lords and my lady, that the action that the members of the National Assembly would be taking pursuant to this 149(9) flows from the delegated authority under Article 1, Subarticle 2. It also flows to the role of parliamentarians under Article 94, Subarticle 2, to exercise the will of the people of Kenya, to exercise their sovereignty. In other words, that is a choice that the National Assembly is making as the representatives of their people. And why that is important is the very question that follows, is when making that decision, is public participation an imperative? Our answer, my lords and my ladies, is a straight no. And so that then I give you context. Let me give us what happens in the ordinary elections, and which will be as part of Article 148. Article 148, Subarticle 1 reads, each candidate in a presidential election shall nominate a person who is qualified for nomination for election as president as a candidate for deputy president. Then it adds at Subarticle 2 that for purposes of Clause 1, there shall be no separate nomination process for the deputy president, and Article 137, 1b shall not apply to the candidate for the deputy president. What then do we read from that? It means that a simple reading of Article 148, which is what happens in our ordinary elections, does not call for public participation for the position of the nominated person to occupy the office of the deputy president. Now, if we are to agree, and we have seen it in real life, that is what happens. We don't then subject them to public views around what people think about them, sending memorandum. Once that nomination is done, there is no more that follows, other than the declaration after the election itself. Now, why is this important? It is important because of a submission that was made earlier in relation to other provisions of the Constitution which call for public participation. Examples would be in Article 132, for instance, under the functions of the president, Article 132, Subarticle 2, under the functions of the president, the Constitution says, the president shall nominate and with approval of the National Assembly appoint or may dismiss A, cabinet secretaries, B, attorney general, C, the secretary, the cabinet in accordance with Article 154, and the principal secretaries in accordance with Article 155. It is in that instant that then public participation is called for. So that then when the Constitution talks of approve, it means give an opportunity to the parliamentarians to also interrogate the person that is to be approved for whatever position we have. In this case, it is a submission that the Constitution says vote, meaning elect this person. And the test to be derived from that is first past the poll. In other words, at the point of voting, do the parliamentarians vote to support or a majority of them support the nomination? That is the simple question that will be presented before it is, for determination. Permit me then to move on to speak to the place of public interest in relation to this process. Now, it would be expected that pursuant to the provisions of Article 146(2), that when a vacancy occurs in the office of the president, the deputy president shall assume office as president for the remainder of the term of the president. Number 2, that is Article 2b, that if the office of deputy president is vacant or the deputy president is unable to assume the office of the president, the Speaker of the National Assembly shall act as the president, and an election to the office of the president shall be held within 60 days after the vacancy arose in the office of the president. What is the public interest question? The public interest question is, it is expected, it is a legitimate expectation by the people of Kenya that they'll have a president. In the absence of a president, they will have a deputy president. In the absence of a deputy president, that will have a situation where the speaker would be able to steer the country into an election. The public interest question that we want to ask or present to the court, would it be in the interest of, now that it is clear that there is no occupant of the office of the deputy president, would it be in the interest of the public to expect or to push the country to a potential election under this article because we want to issue orders that would stay the filling of that office? In our understanding, my lords and my lady, that would be pushing the Constitution a little too far. It should not be lost on us that this same petitioner, the mover of this very petition, during the discussions around the motion itself, we had terms like Kufa Dereva, Kufa Makanga. What stops him from filing yet another impeachment motion against His Excellency the President tomorrow? It shall be processed. If it is processed, we'll have walked straight into a constitutional crisis. Now, that militates against public interest. And we're saying crisis because we live in this country, and we know that, as a matter of fact, we do not have a duly constituted electoral commission. Even if it was the case that we have a deputy president as of today, then pursuant to the provisions of, again, Article 134, which speaks to temporary incumbency, such person would not be able to appoint the electoral commission. What then does that mean? It means potentially that the first person to get to Uhuru Park and get sworn will be the president. My lords and my lady, is that a position we would want to allow the country to get into? Permit me to add by saying this, that these constitutional principles are exercised within a particular context. It is a political context. Political context, by its own nature, and I had my learned friends speak to the fact that we live in a constitutional democracy, is a competition. In that competition, there will be those who will be for one party and those who will be for the other party. Naturally, it follows that when one party loses office, there will be some measure of discomfort. What then does the court do? It is in those occasions that the court rises to steer the country through that process, so that then the competing interests are balanced in a way that ensures the stability of the country. And because it's very interesting and very, something to be very proud about in Kenya today, that we are talking about such sensitive issues in this sort of civil environment. My lords and my lady, in other places, when we talk about this sort of transitions, these are constitutional transitions, they end up subjecting the populace to more difficult positions. Now, because we have this opportunity, what then would the court be considering in whether to grant the orders that have been sought or not? My lords and my lady, the constitutionality speaks to something we call utilitarianism. Utilitarianism dictates that the court helps maintain what I would call constitutional homeostasis. That means that we then ensure that whatever decision we take is such as to ensure that there is stability within the country and that the country is given an opportunity to move on. My lords and my ladies, these are jurisprudential discussions that have found favor with those who have been there before us. We've been told in our learning of the jurisprudence about Jeremy Bentham, about Arthur Stuart Mill. They were great proponents of utilitarianism as a concept of constitutionalism. May I also invite you to the works and findings of Roscoe Palmer, who postulates that the law is supposed to be a tool of social engineering, and that then, in its implementation, that social engineering is supposed to help to bring stability within the nation. My lord, my ladies, it only follows that for us to achieve that stability, then the orders that were issued and that there are ex parte are orders that are supposed to be set aside. The country is allowed to move aside. I am most obliged.
My Lord the Presiding Judge, as I settle down and begin to make my submissions in the motion before you, may I kindly request the court to ask that that light, which is a bit blinding, be either angled further up or turned off completely.
The light has had.
I guess that makes it a smart life. You can understand and react. Well, the applications before you for conservatory orders this evening are opposed. For the record, I am Paul Nyamodi. I am on record together with my learned colleague, Mr. Gumbo, for the second respondent. And my lord, I wish to commence my submission by saying that the task before you this evening is a rather simple task. And listening to my colleagues making their submission, one would be forgiven if they formed the impression that what was for hearing before you was the petition proper. It is not. What is before you for hearing are two applications for conservatory orders. And my lord, it is my submission that the criteria, which you will no doubt consider when you retire to consider your decision in this matter, is straightforward. There, as do the petitions before you disclose inherent merit? Would those petitions be rendered nugatory if the conservatory orders that are sought are not granted? And lastly, and most importantly, is it in the public interest to grant the conservatory orders that are sought? I wish to state that the purpose of a conservatory order, or the ultimate beneficiary of a conservatory order, is the court, and not the party that seeks the conservatory order. I say so because the purpose of a conservatory order, my lords, is to preserve a situation so that the orders of the court upon conclusion of the hearing of the petition are efficacious. That is not achieved by returning anybody to office. That is merely achieved by maintaining a certain status quo for the benefit of the court. So anybody who seeks to persuade you that they can be returned to office by a conservatory order, then perhaps has misunderstood what indeed a conservatory order is. My lords, just to pull the strands together from the submissions that have been made by my learned colleagues for the respondent, and the context in which I asked my lords, my lady, to view those submissions, is that they have spoken to the first ground. They have spoken to the first ground in Peter Munya. They have spoken, or they are responding to the question, is there inherent merit in the petitions that are before you? All the submissions about public participation, all the submissions about the Article 50 rights are all in an attempt to persuade you that there is no inherent merit in those petitions.